Welcome on board the Newstrack. I'm Rahul. Kanwal. The Supreme Court has said that a district judge in Varanasi will hear the Gyanvapi case. All the latest on this issue, which is being tracked nationwide, is coming up on the Newstrack tonight. Here are the headlines we are following this evening. India Today accesses 17th century text that confirms that Aurangzeb demolished the Kashi Vishwanath temple. Sighting of a second Shivling on the mosque wall adds another twist to the case. Accused of murdering her daughter Indrani Mukherjee walks out of jail after 6.5 years, says she believes in empathy and forgiveness. India Today news break on the language war explodes as Prime Minister Modi settles the debate, says all regional dialects are worthy of worship.
भाजपा भारतीय भाषाओं को भारतीयता की आत्मा मानती है और राष्ट्र के बेहतर भविष्य की कड़ी मानती है.
Former Punjab Congress chief Navjot Singh Sidhu surrenders in a Patiala court, complains of chest pain before heading to jail. CBI raids at 17 locations linked to RJD Supremo Lalu Yadav, wife Rabri and daughter Meesa Bhati over corruption charges in a land for job scam. The Supreme Court today transferred the Gyanvapi case to the Varanasi district judge. While its order on protection of the Shivling and safeguarding the right to Namaz will continue for another 8 weeks, the biggest issue, that of whether the case is maintainable at all, will now be decided on priority. What are the implications of the Supreme Court's order? Our legal team with our lead story tonight.
अब जो माननीय सर्वोच्च न्यायालय का आदेश है वो मान्य होगा, जो देखा जाएगा उसको, जो एपेक्स कोर्ट ने जो आदेश दिया है वो उचित व जायज है. 10:15 में चूंकि सब मैंने रिपोर्ट ये सबमिट कर दी थी, उसके बाद माननीय सिविल जज कोर्ट में ये दाखिल था. उसके बाद अगर कुछ हुआ हो तो जानकारी नहीं, अभी उसके पहले तक कोई लीक नहीं हुआ था.
The Supreme Court of India has transferred the civil suit over Gyanvapi Mosque to the District Court in Varanasi. A 3-judge Supreme Court bench on Friday passed an order in a petition filed by the Anjuman Intizamiya Masjid Committee. The civil suit over Gyanvapi, which was being heard by a civil judge, senior division, will now be heard by the District Judge Varanasi. In some respite for the Mosque Committee, the maintainability of the case filed by the Hindu petitioners will be heard on priority. The Supreme Court has also ordered the district magistrate to ensure arrangements for Namaz and wazu. The court's May 17th order directing the protection of the claimed Shivling will continue till the district judge gives a verdict, and further 8 weeks to give time to parties to file appeal.
माननीय सर्वोच्च न्यायालय को लगा कि ये मामला इतना सेंसिटिव है और कॉम्प्लेक्स है, इसको ध्यान में रखते हुए उन्होंने डिस्ट्रिक्ट जज से सुनवाई का आग्रह किया है और उनको निर्देशित भी किया है कि डिस्ट्रिक्ट जज इसकी सुनवाई करे, ताकि एक एक्सपीरियंस्ड ऑफिसर और जितने भी रिपोर्ट्स और जितने भी एप्लीकेशन है सबों की सुनवाई माननीय डिस्ट्रिक्ट जज करेंगे.
The Mosque Committee has challenged the admission of Hindu petition by the local court, its order of videography and its orders to protect the pond at the mosque site. The Mosque Committee argues the local court's ruling violates the Places of Worship Act 1991, which ensures the religious character of a place of worship as it stood on August 15, 1947. During the hearing, the Supreme Court asked whether the Places of Worship Act bars determining the religious character of a site. The question will now be touched upon by the district court when it decides on the maintainability of the petition by Hindus. Bureau Report, India Today.
It's now up to the Varanasi district judge to decide on the next date of hearing. But the discovery of a second Shivling-like structure on the mosque's wall has added a fresh twist to this case. While the Muslim side has said that the alleged Shivling in the wazu khana is a fountain, this second Shivling so far seems undisputed.
A second Shivling on the wall of the Gyanvapi Mosque complex has triggered massive suspense. The latest images come just days after videos of another claimed Shivling in the wazu khana of the mosque emerged. The claim of the Shivling in the wazu khana has been contested by the Muslim side, which calls the structure a fountain.
The demolition is well known. It is historically recorded by the historians of the period. There is no doubt about it. Whether a single object discovered there belongs to the temple complex architecture or it does not, it is not of great consequence. As far as I have seen the picture, it does appear to be a Shivling, but obviously close examination will be conducted.
But the second Shivling is uncontested and undisputed. Ensconced in the wall, surrounded by lotus imagery.
Disc-like or tablet-like thing has been placed over it, and the mortar is seen, the white color mortar is seen, and perhaps white cement-like thing, and which was fixed over it, and just to distort the evidence of Shivling.
The Hindu side claims that the Gyanvapi Mosque was built after the Kashi Vishwanath temple was demolished by Aurangzeb. The Shivling in the mosque wall could be a big push for the claim and could settle the Shivling dispute forever. Bureau Report, India Today.
The Supreme Court hasn't ruled on the maintainability of the petitions before the Varanasi court and in the Supreme Court. But what they've said is that a senior judge in the district court will now look at the Gyanvapi case. Also upset with the local judge for reports getting leaked to the media, saying that, you know, while we're not casting aspersions on the judge, but the manner in which these proceedings have been carried out is not right, because you can't have these reports getting out to the public even before the judicial system forms a view on this. Joining me on this broadcast, Hari Shankar Jain, advocate in the Lucknow High Court, has been closely involved in this case. Nupur Sharma is a national spokesperson of the BJP. Squaring off against them is Dr. Taslim Ahmad Rahmani, president of the Muslim Political Council of India. Now, I want to go to Hari Shankar Jain first, because one of the things the Supreme Court bench said today was that this matter coming out in the media, these reports coming out, is not right. The judge seemed pretty upset about it, and that seems to have been one of the reasons why this case was then transferred to a senior judge in the district court. To that extent, would you concede that the hearings in the Supreme Court are a bit of a blow to your side and to the case that you were hoping to build?
No, not the least. This interpretation is not correct. The Supreme Court was not upset, and was never, this question never cropped up. The question was, Supreme Court was of the opinion that a senior judicial officer in rank should decide the controversy, and that is why he entrusted the case to London district judge, because he is the senior most officer of the district judgeship. And it is absolutely wrong to say that court was upset or any information was being leaked. There is no allegation like that.
Taslim Ahmad Rahmani, it is being sought to be projected that the shifting of the case from a junior judge to a senior district judge suggests that the court was upset with the leaks. While there were observations in the leaks, the likes of Hari Shankar Jain saying don't link the two, the judges did make clear it's not as if they're upset, they just think a senior judge will be better able to handle a case as sensitive as this.
No, Rahul, I cannot comment about the future, but what we were maintaining since 16th of May, that it is the judicial impropriety, that the reports are leaked one after another. You see, on the 16th itself, when the proceedings of the commission was not completed, even then, it was leaked that something is found and it is termed as a Shivalinga. and then somebody has approached to the court, so it was a judicial impropriety. And then the manner that on 19th of May, the way in which the whole of the media was carrying the copy of that report, it was a highly questionable thing, and it was raising a question mark on the judicial propriety. That's why I think this is the triumph of the other party, that even the judge has been changed, and the court, the observation of the court were very strict about this kind of impropriety, etc. So, and they have allowed the wazu and directed the district administration to arrange for the wazu, etc. Only thing that the object, which is called the Shivlinga or fountain, has been ordered to be preserved as a piece of evidence to be discussed later. And then with these conditions, the court has allowed the district court to hear this case for the next 8 weeks. And then they said that it is open and no status is going to be changed. The status of the masjid is not going to be changed. So I think we shall wait and watch, and we shall take it in a positive manner.
Okay, so both sides looking to take it in a positive manner, but the fact now is that this case will be heard before the Varanasi district judge, and therefore, given the weight of evidence that now seems to be emerging, are you hoping, Nupur Sharma, that the judge at the district court in Varanasi will look at the evidence that these fact-finding committees have put out, and therefore just the application of the Right to Worship Act will not be in its literal sense, that all these new factors will also be taken into account?
Well, good evening, Rahul, to you and to the panelists and also to your viewers. It's a bit rich, to come here and say that, it's been an absolutely fantastic order. Let's just go back a bit. The original petitioners actually approached the lower trial court with prayer number 1 to go back to the status quo as stood before 1991, which allowed them more regularly to prayer for Mata Shringar Gauri and Lord Ganesha and Lord Hanuman and others in the parisar of Gyanvapi. Because this was a practice of prayer which was allowed more regularly, it is only out of political reasons that Mulayam Singh Yadav's government actually limited that and allowed only once a year prayer to be offered. These 5 ladies had approached the lower court. Their petition was accepted. A survey was ordered by the lower court, against which the opposition party, the caretaking management committee of the Gyanvapi Parisar, approached the Honorable Supreme Court saying prayer number 1, you stay the ongoing procedure, the ongoing trial in the lower court. Number 2, you stay and dismiss rather. This was argued before Justice Chandrachud today, that you need to nip this exercise in the bud. A lot has already happened vis-a-vis the report and the survey being conducted by the ASI as per the orders of the lower court. So it would be wrong to say that their side actually came out victorious, because the Honorable Supreme Court, under the justiceship of Justice Chandrachud, who's going to be a Chief Justice in the future, absolutely refused to stay the proceedings as was prayed as prayer number 1, and point number 2, also refused to entertain the argument that you need to basically dismiss outrightly the findings of the survey report. So what the Honorable Supreme Court has actually ordered is to maintain status quo as far as the interim order given by the Honorable Supreme Court is concerned, which by the way means that they need to keep sealed the area of the wazu khana where the survey report happens to find a Shivling, and point number 2, most certainly to allow the proceedings to go, and perhaps on which is by the way a matter of procedure which they are trying to tom-tom about. Whenever a maintainability petition is filed, that application is usually entertained first before the merits, the court can go into the merits of the case. And point number 3, yes, he did shift it to a higher judicial body, which is something that he has observed, which by the way means that in the entire hierarchy of courts, now the time taken, if ever this comes in appeal before the High Court and the Supreme Court, would be much less.
Sure, and as this legal war over worship continues, India today has accessed documentary evidence to suggest that the Kashi Vishwanath temple was indeed demolished by a Mughal ruler, Aurangzeb. The 17th century text, Masire Alamgiri, written by Aurangzeb's last secretary, details the razing of the Kashi temple. Here's a report.
Was a temple demolished to build the Gyanvapi Mosque in Varanasi? The one question that's central to the Gyanvapi Kashi temple case. And now India today has accessed documentary proof that says that the Vishwanath temple in Varanasi was indeed demolished by Mughal Emperor Aurangzeb. This is the book, Masir-e-Alamgiri. It is an account of Aurangzeb's rule written by Saki Mustaid Khan, Aurangzeb's last secretary. The text clearly mentions that on April the 8th, 1669, Aurangzeb came to know about what he called Brahmin misbelievers teaching their false books to their schools. It further reads, Aurangzeb was eager to establish Islam orders to demolish the schools and temples of the infidels. And so, according to the emperor's wishes, his officers demolished the Vishwanath temple in Kashi.
दीवार दिखाई पड़ती है मस्जिद की, वो उसमें जो मोल्डिंग्स बने हुए हैं वो ब्राह्मणिकल स्ट्रक्चर के होते हैं, प्रायः मस्जिदों के दीवार पर नहीं पाई जाती हैं.
The text was written after the death of Emperor Aurangzeb, but it is about the Mughal ruler's rule from 1658 to 1707. The text clearly mentions that Aurangzeb ordered the demolition of the temple, just like the Hindu side has been claiming in the latest petitions in court.
जैसे घंटी लटकी हुई, उसका वो पत्थर की वो है जो हिंदुओं में होती है, कलश है, फ्लावर मोटिफ हैं जिनसे डिजाइन किया हुआ है, ये सारे उसमें उसके मुद्दे होंगे. ये तीन तो होंगे ही होंगे, क्योंकि these are the strongest proof of the fact that a temple existed there.
Let us say 1193, there has been a cruel history of demolition of Hindu temples. They are egging them to believe that no demolition was done, or if it was done, it was for political reasons. I think this should stop now. People should acknowledge that this has happened.
History has also witnessed that the temples have been tampered with. The evidence found on the walls of the mosque only show that the mosque was built after the demolition of a temple. A shivling in the wazu khana of the mosque, another shivling in the mosque complex on a wall, and now this testimony of what actually happened during Aurangzeb's reign. Will the courts consider these as they deliberate on the Kashi temple Gyanvapi Mosque dispute? Bureau Report, India Today.
So there is documentary evidence from Aurangzeb's own secretary to suggest that the Kashi temple was indeed demolished. In that textbook, we just showed you excerpts from that book. Karuna Nandi joins us as well, advocate in the Supreme Court. Karuna, there was an expectation which many who were opposed to this petition had, that the case itself would be dismissed at this moment and proceedings in Varanasi would be stopped. But given the fact that in the District Court of Varanasi, now over the next several weeks this matter will be heard, does that then, according to you, mean that the court hasn't taken the Right to Worship Act at face value and said, okay, let the matter go on, let the District Court first hear it, rather than the Supreme Court stepping in at this juncture and putting a stop to these proceedings?
These are very strange times, and I think, Rahul, that operating in these times is a very difficult thing for a judge, because for a court, for any court. And this is why I think that going by the strict letter of the law, I think can be useful, because the Places of Worship Act is quite clear that you can't change the religious character of a place. I think the thing to remember is that the fault lines in terms of disputes between various religions, and it's a very religious country, have been happening for centuries. It's just that they've flared up since they have been stoked in the last few decades by certain political parties, and not just political parties. And so interpreting the Places of Worship Act in a way to say that you can't change the religious character of the place because after 1947 it is determined that, look, there were things that happened in the past, let us just give it up now, let's freeze it. I think that was one approach, but it is also what the law says. So what we really need is a Truth and Reconciliation Commission in this country. But who's going to do it? And honestly, if you're not getting proper justice for riots now, and it's a very difficult and complicated situation.
Nupur Sharma, the point that Karuna essentially makes is if the judge had literally interpreted the Places of Worship Act, then this case should have been dismissed. It shouldn't have gone back to the district court. There needn't be a hearing. That's the point that she's making, and she's alluding to how difficult it is to be a judge at this time to say that the law hasn't necessarily been interpreted as it states black and white.
No, untrue. Are you, is she alluding that the Honorable Mr. Justice Chandrachud is actually working under pressure of anything? Most certainly not. In fact, he is somebody who opines and opines as he may will. For that matter, if actually the Places of Worship Act was to be taken at face value, even though the Honorable Mr. Justice and his bench refused to go into the merits of this, then Section 4, Subsection 3, Proviso A would apply. Which, by the way, till date, as per the Himachal Pradesh High Court's order of April 2007 in Satyendra Kumar versus Union of India is that if there is a monument which is roughly 100+ years old and falls in the definition of the ASI Act, whether as an ancient monument or an archaeological site, doesn't necessarily need a notification to be declared so. And in such a case, as per Section 4, Subsection 3, Proviso A, the Places of Worship Act 1991 will not apply. Now to sit here and say that's what the law, well, the law was actually turned on its head when the Honorable Supreme Court gave its verdict in Shahbano. We all know what the Parliament legislated. I am not going to go into whether the Places of Worship Act applies or not. That's for the courts to decide. It's their discretion. I'm not a judge. So I'm not going to usurp that mandate of the Honorable Justices, whether in lower or in high or in Honorable Supreme Court of India. But what is actually interesting is that the Honorable Mr. Justice Chandrachud did say that although under Section 3, the Places of Worship Act bars us from changing the religious character, it certainly does not stop from determining the religious character of a place. And by the way, Section 4 and all that I argued before is something for the lower court to actually consider.
Sure. The other thing that the judges say, and I just want to take you through some of what Justice Chandrachud said about the possibility of a hybrid character for a place of worship, saying that such places with hybrid characters are not unknown in India. Ahmadi said later that there are multiple places where symbols of multiple religions are existing together. There may have been a temple, then a mosque, then another temple of the Buddhist religion. And essentially, is there some possibility, Taslim Rahmani, in some kind of reconciliation which allows for this place of worship to have a hybrid nature, or is it really going to be an either or between a mandir and a masjid?
You see, the first sentence in the previous hearing, the Honorable Justice Chandrachud said it at the very outset that this is not a case, this is not a title suit. This is a suit for the right to worship. And it speaks volumes about what the intentions of the learned judges are. It's very clear that they are not going to touch the 1991 the Places of Worship Act. And that's why they said that act doesn't bar to notify, to identify the area that who were the worshippers or who were not worshipped. But that doesn't mean the status of the place of worship can be changed. But it is the duty of the government to reply the notice to the same Supreme Court of India on challenging petition of this 1991 Places of Worship Act. They did not reply as of now. Now the ball is in the court of the government. They have to decide whether they will have to protect this law, or they have to repeal, or they have to ask the Supreme Court of India to set this law aside. So this has to be decided by
Okay,
by
that's a
their
separate
action.
matter.
It will
Do you see
the-
a prospect
deciding
for a
factor,
middle
what
ground?
will be the course of
That-
the future course of this country?
No, but you aren't answering my question.
Why there
If
is
it
a need of
stays
a
as
middle
a
ground?
mosque,
I don't understand
can there
why.
be a middle ground where
If there is
Hindus
a
can
law
pray as
existing,
well?
What can be the middle ground? And that's why I said what the honorable judge has said at the outset, that speaks volumes about the future of this country. That the status is not going to be changed, but this is a matter of right to worship. So at the end of the tunnel, will any court of this country allow the worshippers of another faith to worship at a place of another place? Say, for example, in a masjid, Hindus will be allowed to perform puja, or in a mandir, the Muslims will be allowed to perform namaz. Is that direction the country is going and our judiciary
Hari
is going?
Shankar Jain,
This is a big question
is
to be
there
asked.
a
And that's why
prospect
I
in your
asked.
perspective of a middle ground, that on certain days Muslims can come and pray in the mosque, on certain important days Hindus can come and pray in the mosque, and the puja can be carried out over there? Or are you seeking this mosque to be reverted back to the status of a temple now, or do you think there can be a middle ground?
No. It is actually, it was a temple. It is a temple, and the entire premises has to be handed over for worship and puja. It had never been a mosque, and the claim of mosque is absolutely illegal, and there is no basis for it. I may remind that there was a case of Deen Muhammad fought in 1935. There was a statement of 16 witnesses. At that time,
not claim it in
this
the
was
court.
a case between
When the honorable court has said that it's not a title suit, you did not object to that.
Not necessarily. Not a title suit. This is misinterpretation. If there is right to worship, that can be asserted by worshipper, and that I have done. I have asserted my right to worship, and I have kindly hear me. Deen Muhammad case,
Right to
they have
worship where?
16 witnesses. In 1936 they have deposed. Yes. What?
No, so let him speak. Rahmani Saab, don't jump in. Let
1936
Hari Shankar complete, and I come back to you in just a moment.
I will complete.
Yes, boliye sir,
May I
boliye.
complete?
Yes, please.
In 1936 case, 16 witnesses have deposed before the court that they were worshipping within the temple premises. This is Adi Visheshwar. And since 1990, Ma Singar Gauri was being worshipped, and the status was of a temple throughout. If someone taking law to hands forcibly and illegally occupies the upper portion of a building or a temple, that will not be converted.
Okay,
into a mosque.
Karuna Nandi,
There is
both
no-
sides
there is
taking
no
entrenched
conflict.
positions on the
That's
show,
all.
refusing the prospect of a middle ground. Does that then foreclose this possibility, or is there at all some kind of middle ground that can be found which doesn't necessarily appease either side, but ensures that there isn't a blow-up in case there's a demand, which is a trenchant demand for that mosque to be turned into a temple, which could lead to the kind of fallout that we saw during the Ayodhya agitation?
I think the person who spoke after me has gotten it completely wrong with regard to what I was saying, which is that I certainly wasn't impugning what any particular judge was saying or indeed about the court. What I was saying was that I think that court operates in a particular environment, all courts. And it's a particularly incendiary environment in which they are operating now, because the members of her party, in fact, are very quick to impugn the court's standing, when they don't like a decision. And that's something that's extremely dangerous and to be avoided. What you are saying, and in fact what the court said today with regard to the hybrid nature, that's a very idealistic, beautiful thing. And it's a little bit different from what the Places of Worship Act, I think, in my reading of it, and readings differ, initially intended, and the Places of Worship Act, in my view, intended that, look, whatever happened in the past, it's all over, and what it is today, it is today, right? From the 15th of August, 1947, and then that continues. What you're saying and what the court was saying today is, I think, a beautiful and idealistic solution. But I think one also needs to zoom out when one looks at such issues, right? Because one sees one is in an environment where the rights of Muslims to perform namaz in various places is under threat. The fact that the right to worship of various religions is under threat from, I wouldn't say members of one religion, members of one political persuasion. And so overall, I think that these very intense difficulties are there.
Okay. So Pinky Anand joins us, senior advocate, former additional Solicitor General, also somebody who has a good sense of thinking within the BJP on legal matters. Ma'am, welcome. Your first sense of the proceedings in the Supreme Court today and the fact that a senior judge now in the district court will be looking at this case. They haven't thrown the case out, they haven't stopped the proceedings. They've also expressed dissatisfaction with the reports getting leaked to the media. Who do you think the proceedings in court today went in favor of, and who do you think they went against?
I don't think there is anything in the proceeding today which went in favor or against as such, because the matter is going to be heard after the vacations are over, and it will be taken up then. But be that as it may, what the court did observe, and I think that has become a fairly public statement, even though it's not part of the order, is the fact that, looking at a survey or surveying a historical site is not something which cannot be done with or without the Act, and the fact that ultimately the Act itself is also being questioned and is being considered, rather, let me put it another way, I think itself is one of the biggest hallmarks. So you have the situation where you have the court looking into the matter, where the court is protecting the rights of, for the time being, both the parties, protecting the site in question. So there seems to be a little leverage up for one of the cross sections where the site itself is being protected, rather than to throw out the matter at the first set. So the fact that the court has entertained and is continuing to hear the matter, including ultimately the challenge to the Public Worship of Places Act 1991, I think there is some upper hand here on one side, but we leave it to the court to take a final adjudication on the matter.
What's the thinking at this moment in the BJP, as you understand it, on the Places of Worship Act? Are you hoping that this case will be decided under the Places of Worship Act as it exists in favor of the Hindu side, or is the thinking that we need to do away with this act because that's the only way in which a mosque can be turned into a into a mandir, because the Places of Worship Act prohibits that?
Rahul, I think there is some error here, and I don't really want to speak for the government or what the government is proposing to do at this stage, because it will be under consideration. But it doesn't really even need to go to that extent. The understanding also, which emerges very clearly, it doesn't have to be a party thought or otherwise, but the understanding which is clear is that there is no conversion. The site stands. The Shivling stands. There may have been partial destruction. So the Act, in any case, the 1991 Act, only prohibits any issue relating to the conversion of a site from one to the other. So possibly there will be no application of the Act. That aside, I think the second issue regarding the Act itself, 1991, or the constitutionality, the basic structure of a constitution says you must have an adjudicatory mechanism. The basic constitutional rights under Articles 25, 26, 29, etc. mandate that everybody has a right to their freedoms. So I think there is a lot to be said as far as...
No, but there will require a change in the status of the site, because facts on the ground are, forget what was the case before Aurangzeb came along, facts on the ground are, at this moment there stands the Gyanvapi Mosque, and Muslims were praying till recently unhindered across the mosque. Now there are certain restrictions, but earlier there was unhindered access, so therefore it will require a reversion in status.
Please.
No, which kind of reversion of status would be required here? You ultimately have the status of the Shivling, the reports which have of course been leaked out, which stand today, which includes a Kalash, which includes a Trishul, which includes a Shivling. Each of them indicate that it exists there. So there's not a question of conversion. How are you converting a site which exists? So that I think is a basic premise on which possibly some of the arguments would go. But as I said, in any case, the Public Worship of Places Act 1991 is under constitutional challenge, and various constitutional challenges have been made to it. So what emerges out of the act and what would happen is a matter which we are going to wait and see.
So you've given an interesting perspective, and I want to bring Taslim Rahmani in on this, that A, the act itself is under question and is being looked at. B, even if the act stays as it is, Pinky Anand argues that given the fact that a Kalash, a Dambru, a Shivling, the Nandi have been found there, it says that it was always a temple and therefore there is no reversion of status that is required. Hindus just need to be given the right to pray over there because it always was a temple.
See, you were earlier also talking about the middle path. I want to remind you that on the 9th November 2019, when this Babri Masjid verdict was pronounced by the Supreme Court of India, our Prime Minister said it very openly, let's forget the past bitternesses and let's go along hand to hand for the formation of this, for the national building. And then the RSS chief of the same day said that we have joined this Andolan for some historical compulsions, but now onwards we have not to join any of such Andolan in future. And just 2.5 years after that verdict, there are 27 cases on various mosques in various states, and the government is silent. And the RSS people are doing all these things. They are creating an Andolan again. So where can be a middle path? And the future, I'm sure about it. I have no doubt about that the future of the relationship between the various sects of the society, Indian society, depends on the future of this act, this 1991 act. If this act is repealed or set aside, then there will be a Pandora box which can be opened, and it may not be the Hindu Muslim alone, it may be the Sikhs, it may be the Buddhists, it may be the Christians, and every community can stand up for the sake of, with all such kind of arguments with Madam Pinky Anand ji and the BJP people are you can draw
Nupur Sharma,
you can
Taslim Rahmani is saying
this is
changing the act
some religious thing
would be a hugely majoritarian impulse. There is a possibility that there could be a pushback in society. It didn't happen after the Ayodhya judgment. It doesn't mean that 200 million people will just take this lying down. This could potentially create social fissures, which a country under distress economically, because of inflation, because of interest rates, trying to recover from the pandemic, it's best avoided at this time. Nupur.
Well, you know, Rahul, just a few minutes ago before Ms. Anand joined the debate, I heard Mr. Rahmani actually come on record and say that, oh, it is under challenge, why isn't the government actually going and responding? That time he was more concerned about, you know, this argument needs to go on. And for your information, the Places of Worship Act was actually challenged by a BJP member. Now he's saying it shouldn't be challenged, it should stay. Make up your mind, but stop threatening the public at large, as you did when the Ayodhya matter was sub judice. Now, point number 2, you know, I think there's a lot of confusion. Please don't try to mislead Mr. Rahmani. The fact is that the original petition before the lower court is not for creation of a new right. As I said earlier, the women, the 5 petitioners, the Gyanvapi Parisar is anyway open to offering prayers to Shringar Gauri on the 4th day of the Chaitra Navratri every year. Perhaps what they have gone for is a more liberal access to Shringar Gauri and more frequent prayers to be offered. As it stood before 1991, before, for political reasons, Mulayam Singh Yadav put a ban on it and only limited the praying time to 1 day in a year. And for point number 3, I would still maintain we need to stop casting aspersions on the judicial discretion, especially of the Honorable Supreme Court. And on the contrary, I heard somebody say that offering namaz has become very difficult. To the contrary, offering namaz, especially Jummah namaz every Friday in a public space, does not attract a sedition FIR before, it stood in a bench. But recital, or rather a declaration of recital in public of a Hanuman Chalisa did. So I do not know where this information is coming from. I do not know of many cases, rather even one, where offering namaz on a Friday, blocking public spaces on a Friday 5 times a day attracted an FIR. But I do know of a very unfortunately famous, rather infamous case of a Rana couple, being booked under these charges.
So you're making the point, let Karuna respond, let that be the last word. This cuts both ways. It's not just one community having trouble in offering namaz. Even when the Hanuman Chalisa is being chanted, depending on what your political persuasion is, depending on which state you reside and which government runs the roost over there, you could be in trouble too on either side.
I think that what the person speaking before me is, just ranting on and on about a comment being made on the court is...
Sorry, don't get personal. Either you respond on facts. Please don't get personal. Either you respond on facts. The person who spoke after you, no, I'm sorry. You get personal, I'm going to call you out. And Rahul, you shouldn't allow it. Rahul, you shouldn't allow it. If I'm ranting, what is she doing? Hyperventilating. If I'm ranting, what are you doing? Hyperventilating. What are you doing? Hyperventilating.
Okay, let her conclude. Karuna,
are you rabble-rousing? How would that sound to you? Please, I'll tell her not to get personal.
Okay,
I can also use these fancy words for her. She's
made your objection known. Let Karuna conclude. Karuna.
I think ad hominem arguments are a very strong tendency of, and shouting is a very strong tendency of particular members of this sort of persuasion. The approach that is required here is a calm...
Madam, you can just speak on facts.
Rahul,
facts speak louder than anything else. Maybe you want to just mention a sedition case on those offering a Jummah namaz. I would take back my argument. I would be happy to take back my argument if you can just cite the FIR number. Registered, ma'am, you're shouting. Stop shouting. Stop shouting, Miss Nandi. Stop shouting, Miss Nandi. It doesn't behove of you. It doesn't bode well of you, Miss Nandi. Stop shouting. There is no reason to shout.
Okay, time out, please. No, once again, this is going to degenerate at a time when social tensions are running high. Just having this kind of a conversation which degenerates into a tutu mema is what I'm trying to avoid. You've let your objection be known. Let Karuna conclude, and then I also need to wrap up because I'm out of time. So Karuna, very quickly, please.
I think what is really required now is the healing touch. I think this decision is, today is not a decision, but today's proceedings are an attempt at that. Unfortunately, I think that the politics involved are not looking for a healing touch. And that is the context in which any law operates. And given that situation, there is a conflict.
Well, what we know is that there is no immediate closure. The case hasn't been cast aside. It will be heard in the Varanasi court by a senior judge, and we will see how this plays itself out. This is a matter that is being tracked closely all across the country, and India Today will continue to bring you all aspects of it. But as I said, we won't tell you which side to take. We'll bring out the facts, allow them to be persuasively argued on both sides of the political and ideological and legal spectrum, and leave it to you to decide who you think had the more compelling argument. For the time being, Pinky Anand, Dr. Taslim Rahmani, Nupur Sharma, Hari Shankar Jain and Karuna Nandi for joining us on the Newstrack. Thank you very much. For weeks now, a language war has been raging. Today, Prime Minister Modi jumped into the debate by declaring that all regional languages are worth worshipping. South superstar Kicha Sudeep, who sparked the language war by taking on Ajay Devgan for pushing Hindi, has hailed the Prime Minister's message.
A massive face-off between superstars from across the country. Ugly personal attacks by politicians.
भाजपा भारतीय भाषाओं को भारतीयता की आत्मा मानती है.
And now, a unifying message by Prime Minister Narendra Modi. India Today's agenda-setting newsbreak on the language war has gotten bigger and reached the Prime Minister himself. Declaring that all regional languages in India are worth worshipping, Prime Minister Modi stated that all dialects were a reflection of Indian culture.
भाजपा भारतीय भाषाओं को भारतीयता की आत्मा मानती है और राष्ट्र के बेहतर भविष्य की कड़ी मानती है। इसका जिक्र आज मैं विशेष तौर पर इसलिए करना चाहता हूं क्योंकि बीते कुछ समय से देश में भाषा के आधार पर नए विवाद खड़े करने की कोशिशें की जा रही है। हमें इससे देशवासियों को निरंतर सतर्क करना है।
That's right, India Today's big news break echoing with the top levels of the country. Prime Minister Modi asserting that prioritizing all languages in the national education policy reflects his party, the BJP's commitment to all languages. Also issuing stern caution, the Prime Minister also said that attempts were being made to deviate from the nation's development issues.
भाजपा भारत की हर भाषा में भारतीय संस्कृति का प्रतिबिंब देखती है। हर भाषा उसे पूजनीय मानती है।
Modi's comments come amidst an ongoing, raging debate over whether Hindi should be considered India's national language. While Bollywood actors have been batting for Hindi on India Today,
I think language is nothing. I think what's most important for me is the emotion. I think Hindi has been our national language, right through. So I think we should respect that.
Southern superstars have been hitting back aggressively.
When I said that, it is not a national language where you have to consider that as the one motherboard or the central focal point and everything is pan-India is, even if Hindi is doing a Tamil, Telugu, it's a pan-India. So it's got nothing to do with that, zone where we discriminate ourselves or we have found ourselves inferior or complexed.
I love, and I've always liked, Hindi cinema and stuff. I'm open if there's any great offer or if there's any nice film on my way. I'm definitely open to do a nice Hindi film.
I wasn't saying I wasn't keen to go into that place. I was always saying that I wouldn't want to do Hindi films. I would always want to do Telugu films. This I've been saying it from a long time. So now I'm very happy that what I've been saying is happening.
The language controversy has turned totally personal as well recently, when Tamil Nadu's higher education minister made an ugly attack.
India, Tamil Nadu, we should have our own system because India is a nation, as the Governor already knows, unitary in diversity.
One nation, many languages, that's the ethos of India, and that's the clear message from the Prime Minister. The big question is, on the back of India Today's big news breaks on this raging issue, do the Prime Minister's words settle the issue once and for all? Bureau Report, India Today.
This is where I wrap up the Newstrack tonight. I'm off to Davos over the weekend and we'll be tracking the World Economic Forum 2022 live all through next week. We'll have top global newsmakers, titans of Indian and global industry, some really sharp insights on the world as it stands today and where it is headed tomorrow. So do catch our coverage from the World Economic Forum at Davos all through next week. Thank you for tuning in. Have a great weekend. I'll see you from Switzerland.
After 2 years of paralyzing pandemic, the world is ready to bounce back. Will shifting power centers make this India's big moment? Risk, resilience and revival on the agenda. What's India's role in the global rebalance? India's top world watcher takes you to the front lines of the global high table with top minds from politics and business for the biggest global brainstorm. Live and exclusive coverage only on India Today TV.